Hi, everybody. Welcome to Constitution Happy Hour. Party down. For those of you, how many people it's your first time at Constitution Happy Hour? Wow, lots of people. Okay. So Constitution Happy Hour is kind of like a book club. We're all reading the same book. The book is the United States Constitution. But it's also happy hour, so grab a drink at the bar if you feel like it. We have a speaker who will speak for, 20 to 30 minutes, and then we'll have an audience questions discussion afterwards. It's kind of like taking a college seminar, hopefully, in a fun way. I want to encourage everybody to share tables. This is a great day to meet your fellow citizens and meet new people. So if you have seats available at your tables, please invite a stranger who might be in line right now at the bar to come and join you. We ask that you please keep your cell phones off and please don't film because it's really distracting for everybody else when there's this big glare in their face. But we are filming this, and hopefully with our speaker's permission, we'll put it up on our website so you can share it with other people. So you don't need to film it yourself. We have pens and paper pads available for you over there if you want to take notes. We also have free copies of the U.S. Constitution. Did everybody get a copy of the Constitution? Does anybody need one? Well, if you need one, you can just talk to one of the ushers. We have plenty of copies available. Over on that table over there, we have lots of other materials that you might enjoy perusing. We have the United States Citizenship Test, so you can find out if you yourself would pass this citizenship test. I can promise you I would get a F- on that, sadly. We also have voter registration cards and a bunch of other sort of civic-minded materials. And I want to remind you, if you know young people in the state of California can pre-register to vote at the age of 16. And when they pre-register, then the day they turn 18, they're already registered to vote and they can walk into a polling place. And information about that is available over there as well. So now we'll get started with the Constitution Happy Hour. My Daily Constitution is a project by the Los Angeles-based artist Linda Pollock, who's over there. Why don't you wave, Linda? Her brilliant idea is to bring people together and engage in creative dialogues about democracy and society. Linda first began My Daily Constitution for a 2002 art exhibition called Democracy When at the Lace Gallery in response to the Patriot Act. Since then, she's initiated Constitution cafes in bars, libraries, cafes, parks, restaurants, churches, and other places where people gather. To quote Linda, "Our Constitution, our democracy is about interpretation. And interpretation means a collective, active dialogue, not just passive consumers and lawmaking producers. The United States Constitution is a living document, part of our quotidian life, influencing us in both large and small ways daily." So that's really why we're all here. We're all subject to the Constitution, and it behooves us to actually read it and know what it says. So our guest scholar tonight is Kimberly West-Faulcon. She's a nationally recognized expert in anti-discrimination and constitutional law. She holds the endowed Bradley Chair in Constitutional Law at Loyola Law School, where she teaches courses in constitutional law, advanced topics in constitutional law, employment discrimination law, constitutional law rights, civil rights, principles of social justice, and social justice lawyering. She's also taught constitutional law at UCLA and USC law schools as a visiting professor. Professor West-Faulcon's writings and legal scholarship draw upon her extensive experience litigating employment and education civil rights cases. Her academic articles have been published by the Yale Law Journal, UPenn's Law Review, UCLA Law Review, Wake Forest Law Review, and the Journal of Constitutional Law, and they've been the subject of scholarly responses, articles, opinion, editorials, and commentary in publications and on legal blogs such as the Chronicle of Higher Education, SCOTUS blog, the American Constitution Society blog, and Constitutional Law Professors blog. Before her academic career began, she was the director of the NAACP Legal Defense and Educational Fund, and before that, fresh out of Yale Law School, she clerked for the Honorable Stephen R. Reinhart on the Ninth Circuit U.S. Court of Appeals, which we all know is the court that cases go to right before they go to the Supreme Court. There's a lot more I could say about her fascinating career or careers. She's incredibly brilliant, but I'm going to keep it short, so I will just ask you all to please join me in giving a warm welcome to Professor Kimberly West-Faulcon.
Claudia, thank you for that gracious introduction, and Linda for having me. And I want to make sure, I do feel like this is a great opportunity to have a night of constitutional law class. So does everyone have a seat? Everyone's in the right place, right? You didn't come to the wrong class tonight, right? There are not that many constitutional law or legal classes going on tonight. But this is a real pleasure for me because I am constantly telling my students that one of the things that I want to confer upon them in my classes is a degree of constitutional law literacy. What's also part of that is a basic civic literacy that I'm also saying in my classes that I want every American to have. And so what's really neat about tonight is you didn't pay tuition, right? and so people who are in my classes have paid quite dearly. Some of them have taken out loans and will be paying quite dearly for many years to come, sadly. And so it's something that I say is a very, still a privilege for them, and that we're quite privileged when we are in our classroom chatting about these important issues. And I often bemoan the fact that we don't have this opportunity with our fellow citizens and other persons in our country as often as I would like. So this is really an exercise and an opportunity and an evening that is near and dear to something that I feel very strongly about. And last point on that, as I introduce myself to my students, I'm a pure constitutional law geek. I'm so geeked out about it that I contend that what we're doing here is part of our patriotic duty. And what's great about this, you get to drink alcohol and participate in your patriotic duty. My students, again, don't do that to my knowledge, right? We don't know what's in their water bottles. But all that said, one of the things that I hope you'll leave tonight with is an understanding of the core reasons we have a Constitution, and that being to protect our liberty, to protect our freedom. There's nothing more American, right, than freedom, freedom and liberty. And the role that we, the people, play in being a check on the government and preserving our own liberty is something that I think doesn't get discussed enough, and that's one of the things I'm saying the average person in the country probably doesn't realize how critical you are to the constitutional structure. So I hope that'll be a takeaway you'll have from this evening, that you absolutely should be here, and I don't know how many people would imagine people in Los Angeles studying the Constitution on a Friday night, but I hope that this will be a trend that takes off across the nation. I told you I was a con law geek, right? I'm imagining this going bigger than where we are. And so what's also very special about tonight, and I've shared this with both Claudia and Linda as well, is that this is not my usual invitation to a food fight over a topic in constitutional law, where as the times that are upon us have come upon us, I've found myself on the receiving end of insults and disparaging comments when I thought, oh, we were just going to have a conversation, maybe disagree here or there about an issue in constitutional law. So what I think is very special about this series and what they're doing this time around is not engaging in hot topics, but instead going to the core of the basic principles of what's in this lovely document here. And so these are some slides that the prior speakers have had. It's been part of the evening, and so I wanted to start with these as well, that it's a basic overview of the Constitution. I'm going to actually, much like I do in my constitutional law class, I like to repeat myself and reinforce things. So you will actually see this reinforced because I do something similar in introducing my constitutional law class. But parts of the U.S. Constitution, the preamble, the articles, its amendments, and Bill of Rights, and the other amendments that are the Bill of Rights. I'll come back to that. And then what the series has been doing so far, and I'm so glad that this is so many of you's first time, because it's my first time too, so we'll maybe catch up through the videos on the ones that we missed, but they're delving into Article 1, which is about the role and power of Congress. Again, I'll revisit that. Article 3 is the federal judiciary, and then Article 2 is what we are talking about tonight, and what we're engaging in about tonight, which is the executive branch. So those are, again, parts of the Constitution. So now we've moved into slides that I use in my class. I like to start in the very first class session with saying, I want to make sure everybody's on the same page. I don't want to lose anyone on the first day, and then they don't like constitutional law. So some people come to my class with an immense amount of knowledge about this area. They have studied political science as an undergrad, and then sometimes I have people who they were STEM folks, or they may have been artists. They don't have that background at all. And again, I think it's really important because these issues, to me, I always say in my class, because I am a big devotee about things scientific, I'm like, this is not rocket science. Now, there are many people who teach in the area where I teach, including some of my illustrious professors at Yale Law School, who made this seem like rocket science, right? Part of the allure is seeming like you're super erudite, and this is beyond the small brains of other people to understand. But I go out of my way, and I hope I accomplish it tonight, to make the point that these are very simple concepts, that these are intuitive concepts, and that, again, all of us who are participating in our government structure are capable of understanding. We should understand, and anyone who keeps us from understanding something is doing a disservice to what the framers had in mind. Because again, we the people are a critical part of the structure of the Constitution. But when I say structure here, I'm really saying I want to make sure nobody gets lost on the first day as to what's in this pamphlet. And so it's in their case book in the first couple of pages. And the first assignment in my class is to read the Constitution the night before you come to class. And then I come and tell them that the Constitution has components. So 2019, the Constitution that's here has both the first Constitution, the original Constitution, then the Bill of Rights, which is the term, the label we give to the first 10 amendments. So nothing fancier than that. Then we have 3 more amendments that were added to the Constitution after the Civil War, the 13th, 14th, and 15th Amendments, that what do we do if we're fancy constitutional law professors? The way we make things complex is we give them multiple names. And so then you're very confused, because why would there be 3 names for the same thing? So these amendments are sometimes called the Civil War Amendments, sometimes they're called the Post-Civil War Amendments, and other times they're called the Reconstruction. In case you learned the first 2, we've got a third one, we'll call them the Reconstruction Amendments to confuse you. But all of those align with when they were added to the Constitution. And then there are the rest of the amendments, 16 through 27. So what I was so pleased and happy to do was to add to my slides, this P is the page number in your actual Constitution. So if you'd like to go along again, I'm going to come back to these in multiple places. So if I go through these really fast, that's because we're coming back to hone in on Article 1, Article 2 more specifically later. But this is already repetition. Article 1 creates the legislative branch. And these are things that when you read it on your own, you'll see how it goes through and says what Congress has the power to do. And that is the article that is focused on the powers of Congress. Article 2, and Article 1 is longer than Article 2. We get the easy night in that sense. Article 2 is a quicker read, and it creates the office of the President of the United States and defines the powers of the President. And so I'm going to see the extent to which I can cover a number of these topics this evening: the method of election, term of office, secession, impeachment, vesting clause, commander-in-chief, pardons, treaty and appointments, receive ambassadors, take care that the laws be faithfully executed. Now, one thing I won't be able to cover tonight, which is, to me, a very important aspect of constitutional law, is the question of theories of constitutional interpretation. And that's a really big topic in constitutional law, and it's really where really the rubber meets the road. Also, I tell my students, I'm from North Carolina, and so we have lots of sayings, and some of them make sense to people who aren't from the South, and others, as I hear them coming off my tongue, I'm like, oh, there's more than one way to skin a cat. What a horrible thing to say, and who was skinning a cat, and why do I want to say that? So I may not be able to help myself because I will just say things, but I know rubber meets the road is something probably all of you have heard of. So where the rubber meets the road often is, how are you going to interpret an ambiguous provision in the Constitution? There are many parts of the Constitution that are rather unambiguous. I mean, now if you have an argumentative law student, we can debate about the meaning of virtually any word, but as a general proposition, I think people are often surprised as to how much of the Constitution is not really up for debate, that it is straightforward and the meaning of the various provisions are unambiguous. But when it comes to a theory and a proper way about how we would go about determining what ambiguous terms like equal protection, or due process, or liberty mean in the Constitution, that's a longer conversation, again, one that I think would be great for a Friday night because I'm a con law geek, but one we won't be able to get to. So some of these things that are in Article 2 are rather straightforward, and I also will highlight the ones where there's less clarity. Article 3, that's the power of the federal courts. Article 4 has the full faith and credit clause, and all these things that when you're done, you're just going to want to run off and go to law school, right? Interstate privileges and immunities clause, the interstate rendition of fugitives, rendition of enslaved persons to slavers, another topic we won't cover tonight, but that is something I always mention on the first day of class. The framers went out of their way not to use the word slavery. It's common knowledge to us in 2019 that the framers themselves, many of them, were slavers. They enslaved other human beings at the same time they were writing this document that was all about protecting liberty and freedom. And that is an hypocrisy and complexity about the framers that we don't resolve in constitutional law, like many of us. We can use an and about ourselves. We are this and that. And so they are both the framers of this document about freedom and people who knew enough about the horror and the immorality of what they were doing not to name it. So if you read the Constitution, you might miss the parts that are protecting the right to enslave other people. But much of it is in Article 4. How new states are admitted to the Union is also there, congressional power over territory and property belonging to the U.S., and the Guarantee Clause. How the Constitution changes, the amendment process is what's in Article 5. And again, this is not me in the PowerPoints just picking something because I'm personally interested in who was enslaved and how the Constitution treated enslavement. It is really unusual for the Constitution to have one type of law that is going to be prohibited, or one type of amendment that's going to be prohibited. So if you do have a night on Article 5, a key piece of Article 5 is that in addition to saying how you can amend the Constitution, it gives one substantive area where the Constitution cannot be amended, and it could not be amended with respect to ending the trade of enslaved persons until 1808. State equality of suffrage in the Senate guaranteed. Article 6, acceptance of previously incurred debts. Another very important one, though, is the Supremacy Clause. The fact that federal law will be supreme. It's something that the framers put into Article 6, and that you can have no religious test as part of the oath of office in this country. Now, Article 7, the ratification process, and then we're done with the original Constitution. All those parts would be the original Constitution, and these are the various provisions of the Bill of Rights. We don't, and we cannot, in a modern constitutional law course, cover all these items. And so law school is really made up of covering a number of these separate amendments in different courses, like criminal law would be just one of these provisions. So in constitutional law, we don't get to all of these. Neither will we get to any of them tonight. Other amendments. So I've already gone through these, but here are some of the greatest hits in the selected amendments, and that takes you through the end of the Constitution you have, 29 through 39. So what does the Constitution do? Big picture, establishes this national government, divides power between the components of the national government. The Constitution determines the relationship between the federal government and state governments, and I would say, here's the big heavy hitter, it limits the power of government, and that's how it protects our individual rights. And so one thing I also like to do on that first day of class, and I'm determined to fit it in here, is to give you a little backstory on how we get the Constitution, and also it's a diagram. I'm really going to create a diagram. What I usually do it with a whiteboard, so we're going to see how I do with the technology, a high-tech version of it. And as I assure my students, there is a neater version to come, so no matter how scribbly this looks, that you'll be able to actually figure out the words later, but I'm going to try my best. But one thing I want to say about the history of the Constitution that is helpful to understand actually brings me to an opportunity to ask a question. How many folks here have ever heard of the Articles of Confederation? Well, that's really good, very good. So the Articles of Confederation being the document that was the precursor to the U.S. Constitution. And so this is always been difficult to read. It's something I've had for too many years now, and I put it on a slide a long time ago. But it is a comparison of the Articles of Confederation and the U.S. Constitution. And the big picture about the difference between the two is what a huge accomplishment it was for the framers to convince the rest of the individuals who had some say and were a part of those who were going to ratify the Constitution that it should that the Articles of Confederation should replace the Constitution, because what the Articles of Confederation created was a loose confederation of the states. It was a grouping that was a federal government, but a very weak one. It was one that could not collect taxes. It was one with a very, very weak executive. The decisions between the states had to be unanimous. You can imagine how much they got done, right? You think Congress is gridlocked. Very little was done, but what was preserved by having a very weak federal government was liberty. They didn't have to worry about liberty when there were just the Articles of Confederation. But that brings me to this blank piece of paper, this blank page. This blank page is supposed to represent, as we begin our journey in thinking about what the Constitution does, it represents liberty. Liberty unrestrained, unconstrained. And this is also a world without government. What I encourage my students to think of is when they see this page and all of the liberty we have, that it's not just two-dimensional, it's three-dimensional, so your liberty bounds off of the wall, and we just have unlimited liberty. And what is great about that unlimited liberty, as I am going to give my go at actually drawing our unlimited liberty here. We're like, what is liberty going to look like? That's a good question here. I'm going to use a hashed line because the idea is it's still unconstrained. And so this is us. We're actually going to go back before America was America. We're going to try and go to, this is our liberty, and me trying to write from the screen. Okay, liberty. Okay, liberty, unconstrained. Some of you are probably experts and have some political theory background, and then maybe others in the room do not. Again, the idea is we all start in the same place. So I'm going to do a quick and dirty political theory talk and say some of you have heard of a fellow called Thomas Hobbes. And Thomas Hobbes had a theory about how we behave as human beings. And he had a presumption that we come and we exist and we have unlimited liberty. But what he thought about us is that left to our own devices without government, our lives would be nasty, brutish, and short. Now, what might that mean? You guys don't have laptops, so you'll have drinks that you love a lot, right? And let's say this table has your drinks, but you want the table behind you's drinks as well. And we live in this world with unlimited liberty. So you can do whatever you want. You're free to do whatever you'd like. So you can find the biggest stick you can find and hit them over the head and take their drinks. And life is great. You have all the drinks. But now this table over here might say, well, we saw what they did, and we want more drinks. So we'll find bigger sticks, hit them all over the head, and you'll have all the drinks. This could be your laptops, your cars, whatever else you have. You know, it's getting a little messy here. Are we in the brutish state of nature where we just have sticks, or do we have cars? It doesn't matter. The point is that in this life where things are nasty, brutish, and short, why your life was short, somebody got killed when all those sticks were used, and they died, and so you had a short life. And so the rest of us have observed all of this, and we decide, maybe all this liberty is overrated. Maybe we're willing to give up just a piece of it, just a bit of it, to government power. We'll have a set of rules where we'll be governed by them all, and hey, one of the first one might be, you shouldn't murder other people, and if you do, we'll put you in jail. That will help the rest of us feel a little more safe. So we give away some of our liberty, and we don't give away all of it. Now here, that's the little part that I'm not on a, let's see, oh, look at me, that's great. I might go really high tech with my students next time. Okay. I definitely can't talk and do this as well as I can with a marker. Okay. So we gave over some of our liberty, but remember it was three-dimensional, it was going off the wall. We gave over some to government power. And now we're fast forwarding. The government we know first here would be state government, be colonial government, the North Carolina colony, the New York colony, things of that sort. So that's the government power we know. And then when the Articles of Confederation are created, we decide we're not going to give all of our government power over to states. We'll give a little bit over to a federal government. And then the key distinction is that when the Constitution is created, we give over a little bit more. The new federal government, after we go from the Articles of Confederation to the U.S. Constitution, has more power than the old federal government had. And what do we have here? We have a nice box. And this box is federal government power. Now, you may suspect I could do a lot with this diagram all semester long, and I do, but we won't be doing that tonight. What we'll be focusing on tonight, and one of the things that the Constitution does, is it creates three parts for this federal government. Article 1, I cannot help but talk. It just means it'll be messier. You get the legislative branch. You get Article 2, gives us the executive branch. And then Article 3, yeah, that was purposeful. I meant for it to be diagonal. No, I didn't. And the judiciary. Okay. Why did the framers do it this way? Why did they create these three separate branches of government? Well, again, they were very concerned about giving too much power to this new federal government. In fact, there were two groups of them. The Federalists, who were concerned, nobody wanted to return or create a new federal government that would replicate the tyranny of King George of England. That was the whole point of being revolutionaries. It was to get out from under the power of a king, to get out from under the power of a despot. It was to be free. That was the essence of what this entire document was supposed to accomplish. They did, however, want to have some uniformity about how they might trade with, let's say, France. I mean, before, under the Articles of Confederation, New York and North Carolina could have different rules. They could impose tariffs on each other. There were plenty of reasons. Let's say France decides to attack, or you have to fight King George again. You need to be able to have an army, and an army that doesn't have to just get voluntary funds for the states. That's what happened with the Revolutionary Army, they didn't have the basics most of the time because the states couldn't unanimously agree to fund them. So there was a lot of incentive to have a federal government that was robust and strong, but their overarching incentive was to create one that was constrained. And so that's something, again, as we dive into Article 2, to be clear that the overarching underlying point of why you have a separation of powers and you have three branches of government is to protect our freedoms. And so even though the original Constitution itself doesn't set forth particular liberties, that's not really what Article 1, Article 2, and Article 3 do. There are a few individual rights described, but mostly it's about structure. But what I try to tell my students over and over again is that that part of the Constitution is as much about your civil rights and civil liberties, if not more so, than the rest of the Constitution. Because a key feature of the way the Constitution operates is that this government, the federal government, is a government of limited power. And what that means is that when you take an action, and the way this diagram works, I put a little X, and that's an action of somebody who's in that's the president, has done something. I could put an X in the legislative branch, and it's an act of Congress, it's a law. But the only way when you act, it is constitutional under our Constitution, is if you stay within the power the Constitution gives you. And that's a key feature of federal government power. And the framers set up the articles that way, that as we go through the clauses that give the president the power tonight, the point is that's all the power the president gets. This is in contrast to states. States exist and pre-existed the federal Constitution. The Constitution, the original Constitution and the Bill of Rights, doesn't reference state power. It's not until those other amendments that are for another night of study, the 13th, 14th, and 15th Amendment, after the Civil War, did the Constitution even really engage with states. And so states have a general police power, and states don't have to before they assert, or you can't sue a state for acting. States have a general police power to do things like protect you with police and to keep you healthy and things of that sort. That's in stark contrast to the U.S. Congress, the U.S. President, or the federal courts. Any action of any of those branches of the federal government is only constitutional if they are exercising a power that the Constitution gives them. And so that's the first step. Like if you, and we know everybody would want to take my con law exam after tonight, right? If you took my constitutional law exam, that would be the thing that I would say. If the actor in the fact pattern is a federal government actor, the first step in your constitutional law analysis would be, is the action within the scope of that actor's power? And so that's a very significant way of understanding before we even dig into Article 2. That the precursor to Article 2, and Linda and I have had some conversations, there has been comments by our current president who, unlike prior presidents, some of them, not all of them, but many of them have been lawyers, some have many have been in public service for quite some time. They have a very high level of civic literacy and understand the limitations of federal government power. What we've seen from President Trump are statements that run very counter to an understanding that no actor in the federal government has general police power. In fact, that's a dirty word if you read into a particular set of constitutional law cases, that when you want to disparage an opinion, you say you're acting as if there is a federal police power. And that's what I tell my students. They come to law school to understand why that's a disparagement, right? It's like, that doesn't sound very, very like an insult, but it's a big insult because that's not how federal power is supposed to work. So no entity, whether you're President of the United States or Chief Justice of the Supreme Court, no one has power that just exists independently because you hold the office. You have to find in the Constitution an allocation of that power to you. Now, there are many powers that these entities have, but I'm just saying as a matter of assessing whether they quite literally stay within their power box. That's how you act constitutionally. The first question is going to be, is what you've done within the power that Article 2 gives you if you are the president? And so the other reason we have these co-equal branches is that there's an underlying theory, James Madison in Federalist Number 10, that the accumulation of all powers in one hand is the very definition of tyranny. So that's the underlying assessment for all the branches of government, whether it's Article 1, Article 2, Article 3. If we were doing Article 3 tonight, that I would have a slide with Thomas Jefferson expressing his concern about the justices on the Supreme Court being oligarchs, being tyrants. I mean, that is also part of the analysis of how we keep our power, because we can be the victims of tyranny by any of these three branches of government. So the whole beauty of the structure of having the separation of powers and the checks and balances is to keep us free. It's not to empower any one of those three entities any more than the others. The framers did not want to repeat the concentration of powers they had seen and experienced by being subjects of England. They were extremely determined to avoid that. So that's why they gave us a system that we constitutional law geeks think is quite elegant. It's an elegant system because you have to have at least two branches of government to accomplish anything. In order to enact a law, you need both the executive and legislative branches. To enforce the law, the judiciary needs the executive and the legislative branches to take action to comply with judicial rulings. Or you need the prosecution by the executive branch and the conviction of the judiciary. No one branch can do anything solo, and that's, again, to keep us from being the victims of an all-powerful branch. So it's all, again, in the furtherance of keeping us free. And so this separation of powers, again, is a technique to protect individual liberties. And so that does, and I already made a reference to congressional gridlock, it does make government action more difficult. But what I want to point out, and I always point out to my students, is that was purposeful. The framers didn't want Congress to be able to pass 12 laws a day. Because that sounds great until you actually live in a world where Congress can pass 12 laws a day, and what if they aren't good laws? I mean, that they intentionally made it a system that was clunky. So we, the people, would have some opportunity to pull them back. And the phrase that I use, it's a very technical constitutional law phrase. My students a couple of semesters ago gave me a T-shirt, "Throw the bums out." But that's your role. That's our role as citizens. That's how we're a check on the process for all but some of you think they're bums in the black robes, right? We don't have that check on the Supreme Court, but for the others, that's your important check, and that's why it's important for us all to be engaged and to understand what the limits of power are, so we can throw the bums out if they get out of their box and violate the Constitution. So the other lines are not ones we need to worry with tonight, but this one is the division of power between state and federal governments, and this is the line that's between both state and federal government and our civil rights and civil liberties. So as far as this diagram goes, you could cross over it if you're a government actor and violate the Constitution in various ways. The overarching point, though, of the diagram is there's an onus on all of these constitutional actors to stay within their box. And when they get out of their box in any direction, they violated the Constitution. And so in my class, we go through, and when we study cases, we examine how individual cases fit into that diagram. So this is the neat and pretty version of it. But most of the time, it looks like that on the board. And I've drawn it so many times, they are pretty used to figuring out what it is. So this is what we're doing tonight. And I don't intend to talk all evening. And so we'll kind of see how time goes. And I will encourage Claudia and Linda to help me keep time. But I've already said this, like in my class. I said now we've done it 3 times. Now everybody knows that Article 1 is the federal legislative power, Article 3 is the federal judicial power. Here, and we're not going to do this, but here's a question that after we've studied the nature of the judicial power, I hand this out in class or read from it and ask the students to evaluate. Let me see if it's, you are White House counsel, and the Supreme Court has ruled in a case. You have the power to grant pardons, and you are of the view that there's a person who's been imprisoned, and the law under which they were imprisoned is unconstitutional. And then the question there to ask is, does the president have the constitutional power to issue the pardon? Does he have a moral obligation to pardon the defendant? This is the only time in constitutional law I actually asked them about morality, but it says something about the executive branch and the discretionary nature of the pardon power. And how would you advise the president? Should the president offer a public explanation? What form should the public explanation take? The point ultimately will be in recognition that every actor in the federal parts of the government, as well as the state governments typically, pledge an oath to uphold the Constitution. And they have an independent authority and duty to abide by the Constitution. But there are some aspects of the Constitution that give discretionary power to constitutional actors, and the pardon power is one of those powers. So you cannot, typically we teach you that you can't challenge, you can't go to court and sue the president for how he exercised his pardon power, whereas there are other powers where you could sue the president. But I have to say, times are a-changing. When President Trump put the hypothetical out of could he pardon himself for a crime or something of that horrible nature, then it took something that we had said, well, as a general rule, it's your power. But then that brings me to an overarching point about constitutional law. Whether it is a power or whether it is a right, there are no absolutes. You don't have an absolute right to do anything, no matter what your friends and family may say to you at Thanksgiving dinner. There are no absolute rights. There's, depending upon what the government's interest is, you can be regulated. But depending upon what's the right and what the government's trying to do, there's different variations in that. The same with powers. There's not unlimited power to take any action. And so what we don't have, though, is a Supreme Court that issues advisory opinions. The Supreme Court of our Supreme Court, there are Supreme Courts and courts in the world where the judges on the court will answer questions about which you're curious. Our court decided early on in an opinion that was literally opinion of the justices when an early U.S. president asked the court, can I do this? Is this constitutional? And the U.S. Supreme Court says, we only decide cases when they come to us. We don't decide general questions. And so there are many questions that my students can ask me about constitutional law, where I'll say, well, I have a theory as to whether or not that's constitutional or not. But as a doctrinal matter, meaning as a matter of settled constitutional law precedent, there is no answer. And the reason there's no answer is because there's been no case that went to the Supreme Court. And without a case, we can't tell you for sure whether something is constitutional or unconstitutional. Because we want people to get their money's worth for their expensive tuition, we have a fancy term for it. It's called justiciability, whether a case is justiciable. And the court often holds that certain issues are non-justiciable because they are political questions. And you might think that it might have something to do with Republicans and Democrats. It doesn't. It's instead that it is an issue that the court deems to be outside its purview. And I won't go back to the boxes, although with my students, I'm always going back to those boxes. I'll just ask you to remember them. There was the box that was the judiciary. It's essentially the Supreme Court saying, we're going to stay in our box. And our box doesn't mean getting out of it to go and evaluate the constitutionality of a president's pardon power. Again, except maybe if we reach some extreme circumstance. But as a general rule, that's a non-justiciable political question. Why I'm bringing up justiciability tonight is that we're talking about a part of the Constitution where most of the issues are non-justiciable in the view of the Supreme Court. So if you see any talking heads, and I literally tell this to my students, if you see a bunch of talking heads on cable news saying, I know for sure whether X action of this president or that president is unconstitutional. Now, again, I have to admit, in this current presidency, we get some pretty extreme hypotheticals. But this used to be more nuanced, right? In a more nuanced circumstance, something other than I can go to Fifth Avenue and shoot someone and now I won't be prosecuted, which I'll get to. I really want to engage with that doctrinally. But most of the time, if it's a nuanced question and someone's saying, I know for sure exactly what the Supreme Court would do here or there, if it's in the area of presidential power, it's probably that they're overstating what they know and what they can predict, because we just have very few cases in this area of law. So if you wanted to pick an area that you wanted to become an expert in, you could probably yourself read all of the executive power, presidential power cases, before the end of the year and still do whatever else you like to do in your free time. There are just not that many cases. So in that sense, maybe I got the easy night. So I've already answered the question that I provided for you tonight. How often does the Supreme Court issue opinions on presidential power? So A, B, or C? Absolutely. C, hardly ever. And so as I delve into separation of powers and presidential authority, we have these provisions. And again, it's probably the quickest and shortest part of the Constitution that is one of these major articles that you could read, is we have wording that says, the executive power shall be vested in the President of the United States. To make that even sound a little fancier, we call this the vesting clause, but that doesn't tell you any much more about what that power is. And then it tells us how long he can hold his oath of office. Whether you can interpret the he to the she, I would say that's another night, right? Theory of constitutional interpretation, but I will restrain. Electors clause, Electoral College, qualifications, no person except a natural-born citizen of the United States, ambiguous provision, possibly, right? Does natural-born mean people who are born by cesarean section can't be president? You haven't heard that one? That's like they throw that one out there because you're not a natural-born citizen. Or does this mean you were born in the United States, and when Senator Ted Cruz was running for office, does it exempt him because he was born in Canada and is a citizen of the United States, but is that somehow not naturally born? Do we have answers to these questions definitively with Supreme Court cases to back them up? Not at all, because it's only going to be decided by the Supreme Court if there's an actual case with actual litigants. The court's argument is that's when we'll be able to do our best job of deciding it. If we issue advisory opinions, we'll rule on cases without having the parties properly argue them. How old do you need to be? How long do you need to be a resident of the United States? Emoluments. Never got any action until recently. There were 2 law professors who wrote about emoluments, and one I'm not even sure if he's really a law professor. So there's just one lady, and she has become quite famous in the last several years as law professors go. She's got big-time law professor fame because she had written some law review articles about the Emoluments Clause. Do I have any cases for you about the Emoluments Clause? No. Because without a president having previously taken something that someone thought was an emolument, and that case going to the Supreme Court, if everyone divests themselves, and always think about Jimmy Carter, I'm a Southerner, right? And Jimmy Carter and the peanut farm deciding that that would be a violation of the Emoluments Clause for him to retain the peanut farm because people would be trying to curry favor with the president by buying his peanuts because he did sell the peanut farm, and because other presidents have deemed this to be part of what you must do, we don't have a case that I can point you to. So we only have an interpretation about what this clause means. The commander-in-chief power. The president shall be the commander-in-chief of the Army and Navy of the United States. The one that I've also highlighted that shall have the power to grant and reprieve pardons, except in cases of impeachment. So if someone is impeached, the president cannot pardon you for that. That's textually here. But the extent and the broadness of the commander-in-chief power is also a big question in constitutional law. What does it mean to be vested with the executive power? What does it mean to be vested with the commander-in-chief power? We don't have, again, very many cases on this topic. How about the take care clause, page 17, Article 2, Section 3? There's not a lot of text there. It just says the president shall take care that the laws be faithfully executed. That gives the president the power to execute the laws, but when you are outside or inside your box is something that in other areas of law, when it's the Congress acting, we have a lot of cases, and the case book that I teach from is full of cases where the students learn, okay, well, here's the standard of review, and here's what the court has said about this law, and we have all these laws that are unconstitutional, and these laws that are constitutional, and we know which ones are in the box and which ones cross the line. We don't have this when it comes to presidential power. Another reason we don't have this is a big picture point that I cover even before we get to Article 2 is why would the court have a non-justiciability doctrine? Why is it going to stay on the sidelines sometimes? One thing to also note about the court itself is that it has only the power of the pen. Some of you have probably heard of this, that Congress has the power of the purse. Congress can spend. The executive has the power of the sword, meaning the military, and you can back up with what you do with the Army or the Navy, whatever you'd like to do. And what does the Supreme Court have? I guess the power of the laptop number now, right? But it's not a power that it can use in a way to force the other branches to comply. So we could put aside the court's observation that, hey, we don't want to issue advisory opinions, and say the court has an institutional interest, a self-interest in staying out of the way of a president that wants to do something. Because if you get in the way of a president who wants to do something, and you have no power of stopping that president, you issue an order and say, President X, don't do Y, and then they do it. What kind of institutional credibility do you have? What happened to your power? It went away like that. And so there is a way in which there's a self-interest involved in the court saying, we're going to stay out of this. And so that's another reason we don't have a lot of cases in this area. That could be frustrating to those of us who are like, well, what happens when the president gets out of the box? Isn't the court going to come in and help us and save us? No, that's the other. I'm also calling myself constantly a Debbie Downer. If you're expecting all the answers to be in the Constitution. When I say it's really important that we're here tonight, geeked out on constitutional law, it's because if the president gets out of the box, the entity that is expected first and foremost to be the check on that is the voters. And to the extent you vote the president back in, then you are saying, I'm good with that. Like, everything you're doing works for me. Because, again, the court really doesn't have the institutional power to do much about it. And if the court doesn't sense that the people are with them, they're even less hesitant to get involved. So that's, again, an overarching point. That brings us to the Impeachment Clause. You can be impeached for treason, bribery, high crimes, and misdemeanors. The president, vice president, and civil officers, so federal judges can be impeached. Various individuals can be impeached. The real emphasis here is to be clear that the key interpretation and the longstanding interpretation based on what the framers wrote in the Federalist Papers is that the word high modifies just crimes. Maybe it modifies high misdemeanors, but you do not have to be guilty of a crime to be impeached. And you get this not from this text. Anyone who reads it could see that maybe treason and bribery and crimes are pretty clear, but what would be a misdemeanor would be open to interpretation. So to the extent that constitutional law scholars have an opinion that you can be impeached for something other than a crime, it often stems from reading the Federalist Papers and what some of the framers had in mind. And they speak of things as non-criminal as being of bad character, that they were quite concerned about electing to the highest office of the presidency a person of low character. So while it's unlikely you would have a president be impeached by the Congress for just being a lowlife, you could actually go into the Federalist Papers and make the case. That's why we've had multiple articles of impeachment that have been suggested. Not all of them have actually been adopted by the House of Representatives, but sometimes the article of impeachment, this happened with Bill Clinton, is that you lied not to the grand jury, but that you lied to the people. Justice Kavanaugh was part of Ken Starr's group that was investigating President Bill Clinton's impeachment, and Justice Kavanaugh was one of the people on that team that advocated for impeaching President Clinton because of his lies to the public. So one single lie to the public could be within the misdemeanors word in the Impeachment Clause. But who impeaches? That is in another provision of the Constitution, but it's the House of Representatives. We're all constitutional law scholars in that area right now, right? We know that the House impeaches and the Senate removes. And so I want to run through a couple more cases, but let me ask for a time check. How am I doing? Okay, good. Okay, so I want to give you a couple of cases. Since I said there are some cases, and we can cover a lot of them because we can cover the majority of them because they're so few, or at least the major ones. A heavy hitter, and if I don't have, and sometimes I don't, because I used to have 7 units of required constitutional law, and for me that was the best of all worlds because I'm a con law geek. But now my law school has 4 units of constitutional law that are required, actually fairly common too. They kind of jump around from law school administration to law school administration. But if I don't have time to do all of the executive power cases, I can justify it, one, because I told you there aren't that many. I also told you the court says most of them are non-justiciable. And I also can say if I teach you Youngstown versus Sawyer, you'll be in really good shape on the exam if I give you any executive power questions. So you too will be in good shape and I often say this to my students, depending upon the time of year, I'm like, at Thanksgiving dinner, because you're the law student, right? You're going to go to Thanksgiving dinner, all this stuff is going on, people are going to ask you questions, and if you don't do a good job, job. Maybe the person who might be helping you with your tuition might say not going to pay anymore, or you'll just generally not be as cool. So we got to get your Thanksgiving dinner discourse ready. And if it's later in the year, I talk about the 4th of July barbecue or whatever barbecue you go to. So right now, I think it's Thanksgiving dinner time, and you too can wow your family with your assessment of whether President Trump's actions are constitutional. And without reading the case and without knowing too much about the underlying fact pattern, but let me give you just a bit. This is a picture of steel mills, and this is a picture of President Truman, and this is where I have to make some of the students who are not history buffs feel comfortable and go, no, the exam won't be about the underlying history. The exam is going to be about the legal claims that are underlying this, so you don't have to know all of the details. But the U.S. was involved in the Korean War, and as this is also the night where I can engage with the question of what kind of powers does the president have with respect to war, and what some of you may know, and what's in this document here, is that Congress has the power to declare war. So if you were here on the evening where you did Article 1 in congressional power, that's there. But yet, as I will say in a few moments, we have a lot of military involvements, and it's become increasingly more common in our modern era that the president initiates and Congress never approves. And so that's actually true of our involvement in the Korean War, that President Truman never asked Congress to declare war. So that's an aside, but it relates to Article 2. So the background in Youngstown is that U.S. steel workers were ready to strike. They were about to strike for higher wages, and President Truman had been involved in trying to resolve the strike, and the steel industry wanted to raise steel prices for the government. But again, we're at war. We're in the Korean War. And so President Truman is concerned about the price of steel getting to a point that it will decrease our ability to keep the nation secure and do well in the war. And so what did he do? He ordered the Secretary of Commerce, that's the Sawyer in Youngstown versus Sawyer, to seize the nation's steel manufacturing companies. It's steel mills. And that may seem like, what in the world? That's like the nuttiest thing anyone could do. But it was actually, there was precedent for doing this. This had happened before. FDR and other presidents had seized private industries during prior wars. So it wasn't just completely off of the beaten path. And significantly, there was also some statutory authority, federal laws passed by Congress, that authorized a president to do this under certain circumstances. So Truman's rationale for seizing the steel mills was that the nation needed the steel industry to keep operating to avoid a national catastrophe. And if there were inflationary prices on steel, that would be a huge problem. So the details, again, are some that, and I'm, again, always, you actually are here on the Friday night interested in constitutional law, so it may be less of a joke with you, but when I don't get to something in my constitutional law class, I often say, and you can read that on your own, that case, during winter break after the exam. And I always get a good laugh, right, because everybody's like, that's absolutely laughable. Or if it's the spring semester, you can read that by the pool in the summer. But for you, I'll say, you can read the details on your own, but what I want to provide is what I provide to my students after they read the case. So we get a 6-3 ruling that President Truman did not have the power to seize the steel mills. But that's not why I want to share the case. I want to share the case because it gives you all we have with respect to a standard, a legal standard. And again, you're not preparing for an exam, but my students are. And I'm like, you want to write something down on a note card or whatever your modern version of a note card is. You want some law, right? Something you can apply as a rule. And so Youngstown versus Sawyer, not in the lead opinion by Justice Black. That's also something I say. You paid all this tuition because someone who read this case on their own would think that the lead opinion, the one that says opinion of the court, would be the majority rule, which technically it is, but then when the court says it is and it isn't, and you got to come to law school to learn the couple of cases that fall into that category. And Youngstown versus Sawyer is one of those. That despite the lead opinion being written by a justice who I love to describe Justice Black because his philosophy of law, now he's not Justice Jackson, so again, this is part of what you're going to remember if you read the case. It's not Justice Black's rule that becomes the rule going forward, it's Justice Jackson. What was Justice Black's rule? Justice Black is the guy whose name goes with how he likes to interpret the Constitution, black and white. really bright line rules. Bright line rules. How would Justice Black figure out whether President Truman has the power to seize the steel mills? He would read this document, open it up to Article 2, look and see if anywhere it said you have the power to seize the steel mills. Because remember, that's what the federal government is. It's a power, it's a government of limited power. I didn't use this term yet, but it's a government of enumerated powers. It's a government of listed powers. Again, we got to have 3 or 4 ways to say the same thing to confuse you, but that is the point, that you cannot act unless you get the power from the Constitution. But Justice Black's view of how you get the power from the Constitution was quite literal. He's also the guy who was very literal about the First Amendment. So it means that it's a much narrower First Amendment if Justice Black had ruled the day than what we have, because he says, well, it only says Congress shall make no law. I mean, he gets really specific and focused on the text to, as his critics would say, to an exclusion of the underlying theory, the underlying purpose. So the court hasn't adopted Justice Black's approach, because imagine a scenario where you might want the president to act, and we have plenty of scenarios where we are of common mind. We're attacked. The nation is attacked on American soil, and there is not time to call Congress together. Should the president be able to act to defend the nation in that circumstance? How many people think so? Yeah. I mean, you probably want to know more, right? You're like, well, what is the attack? Like, we're all very nervous about everything nowadays, but assuming that those facts are just kind of the basically true facts, you wouldn't want the president, and after you read Article 2 in its entirety, if the president were limited to just what literally is listed as a power of the president, there would be very little, and that's even in contrast to Congress, which has a number of listed powers, but that's not even how Congress's powers have been interpreted. Congress has both those listed powers and the powers, implied powers it needs to execute them. So what Justice Jackson did was to set forth a zone analysis. Again, that just makes it sound fancy, right? But here's the visual I thought was a better way to describe it. It's like a red light, green light, if you've ever played that game. And that's what's in this decision. It's Justice Jackson illuminating for us a standard that I'm saying, again, you could apply if you went on cable news later tonight or you were at Thanksgiving dinner. The question would be, is the president's action within the box, is it constitutional? Well, if Congress has approved it, or the Constitution approves it or explicitly says that the president has that power, you're in a green light situation. That's when this decision says the president's power is at its highest point. That's when you have the most power, and it makes a lot of sense. It's like your parents saying, you can go out tonight, and then you're good to go when you go out. If you got the red light or the stop sign from your parents, and you still went out, so the Constitution doesn't give you the power, or Congress doesn't give you the power, or more explicitly, disapproves. If you have explicit congressional disapproval, or an explicit part of the Constitution that says you can't do this, then you're in the red zone. And now some of you are getting why I'm saying this is not rocket science, right? Like, con law is not that hard, right? And then there's a middle zone where we don't have, there's silence. If there's silence from the Constitution, if there's silence from Congress, then what Justice Jackson says, in contrast to Justice Black, is that then the president may still be able to act, even if it's not super clear in this document that what the president's trying to do is within the president's power, and that's presumably where the court might step in and analyze. But what I tell my students is going to make them safe, because they wonder then, well, what is the standard I apply when we're in the yellow zone, Professor? How do we know whether the president has acted constitutionally there? And the trick here is that the Supreme Court always makes sure, and it doesn't issue many of these cases, but in this case, whether they were in the dissent or in the majority, meaning they were upholding the action of the president or striking it down as unconstitutional, they made sure it was either red or green. They didn't want to touch yellow, because yellow is where the buck stops with them. When we read the decision, we'll go, oh, you, the Supreme Court, are why we lost the Korean War, and they don't want that, right? So those who held that Truman had violated the Constitution read the same set of facts that the dissenters read differently and said, Congress has disapproved. Congress disapproved here. Now, Truman said, I sent Congress a letter, and told them what I was doing. And so if they had wanted to explicitly disapprove, they could have. The other rub is that the court can also decide that Congress implicitly disapproved or implicitly approved, and you start to see how there's a lot of wiggle room for the court. But the big picture point is, if you are in a fact pattern where Congress has disapproved, and it also tells you that how those checks and balances work. If President Trump is saying, I can take this money and spend it at the border, even though Congress allocated the money for something else, as con law geeks, or at least this particular con law geek, when I did a panel on it, the thing I was trying to tell, we did it within the law school, it was like, well, Congress, everybody's saying, well, why are they going to pass a resolution? Doesn't matter, it doesn't do anything. But if it goes to the Supreme Court, and it's a Youngstown, again, this is why I'm geeked out, right? Like, I'm so excited about this. If it goes to the Supreme Court, and you have Youngstown analysis, and they actually pass a resolution and say, we explicitly disapprove of President Trump using this money this way, that puts him in the red zone. But if Congress doesn't say anything or doesn't do anything, then you're more in the yellow zone. Or maybe, depending on who's on the Supreme Court, they interpret it, well, you didn't do anything, and guess what? Not doing anything can be implicit approval. So it's really important, and what I would say is between the three branches of government, a lot of why we've seen such a great increase in presidential power in the modern era, irrespective of whether it's been a Republican president or a Democratic president, is congressional acquiescence. It's the Congress not being the check on the executive branch that it can be. Now, the Congress can also punt back to us, the people, and say, but you don't like us. Have you ever seen our ratings? You really hate Congress. And if you really wanted us to be more of a check on the president, if you didn't want the president getting into all these wars and sending troops all over the world, you wouldn't keep voting for those presidents. And if we pull funds, because remember we have power of the purse, if we pull funds from these wars, are you going to throw us out? Are you going to decide we're the bums? And if you are, which is what has really motivated most members of Congress not to be a strong check on the executive branch, because we generally have had an American public that's like, yeah, rah, rah, let's go fight, and don't be anti the military and things of that sort. And I'm not trying to belittle the importance of when we should be involved, but the point is that, again, we the people are part of this structure, that if we put pressure on our members of Congress to be more of a check on the president, or if we just seemed more dissatisfied with large exercises of executive power, then maybe Congress would exercise its own power a little more. But, there's plenty of analysis to go around. So then I have a couple more questions. Must a U.S. president comply with a judicial subpoena? A judicial subpoena. You guys think I'm talking about President Trump. He hasn't really faced one of these yet. This is a different case. What do you think? Yes or no? How many yeses? Okay. Anybody brave enough to say no? He doesn't have to comply with a judicial subpoena. Well, we don't know. It depends on who the he is. But this he, must a U.S. president comply with a judicial subpoena? If it's about a congressional subpoena, for anybody who was thinking I was asking that, the Supreme Court has never decided that actual question. Okay, so we don't have an answer on that. Why don't we have an answer on that? Is the Supreme Court asleep at the wheel? Not necessarily, right? They say they only decide cases and controversies. So you'd have to have a president who failed to comply with a congressional subpoena and that go to the Supreme Court, they take the case, say it's justiciable, and then we'd have precedent on it. So the fact there's not a case doesn't mean it's something the president can do. It just means we don't have an answer. But U.S. versus Nixon answered that question with respect to a judicial subpoena. That's what President Nixon was faced with. And he argued that he had executive privilege, an inherent presidential power to exert executive privilege, and that he couldn't be required to comply with a subpoena to produce the documents in in what was stolen from the Democratic Party in the Watergate theft. And so he had tape recordings and he had documents, and he didn't want to give those over. And in that case, the Supreme Court held that President Nixon did have to comply with that judicial subpoena. Now, you could always distinguish any case based on the facts. And so that's why, again, we have to delve a little bit in the facts. But what we knew explicitly and what it says in U.S. versus Nixon. Quote, in this case, the president challenges having to, and this is out of the quote, having to produce materials subpoenaed, and the emphasis here, it's in all caps in my notes, for use in a criminal prosecution. When you read U.S. versus Nixon, what is extremely clear is if there is a crime at issue and the federal judiciary is investigating a crime, which is what was at issue in U.S. versus Nixon, you have to comply with the subpoena. The President of the United States was not, could not opt out or say there was some privilege. And because it wasn't an issue of national security, there was no reason that that subpoena, in the words of the Supreme Court, could not be complied with. They said, we're not going to allow you to avoid the subpoena based only on a generalized interest in confidentiality. These are materials that are sought for use in a criminal trial. The other big piece in U.S. versus Nixon, though, because I've already discussed it, is was Nixon going to comply? Like, that was also the big, important, unanswered question. When the Supreme Court there are many of them, but stuck their neck out and said, we're going to force the President of the United States to comply with this subpoena. If President Nixon had not, to some degree, been the patriot he actually is. I mean, there's all sorts of problems with President Nixon, but he did comply with the subpoena, and he provided the smoking gun that led to his impeachment, his proposed impeachment, and his then resignation. So we do have one answer. If it's a criminal trial and it's a subpoena, you've got to comply. War powers. Can a president wage war without congressional approval? I kind of already answered this one a little bit, right? As a matter of constitutional law, what's in the document, can you wage war without the Congress's approval? No. So I've got no, but they still do. What has Congress tried to do to rein that in? They passed something that not everyone's familiar with, which is the War Powers Resolution. It's a law. It's a law in the books, and it creates rules of the road for when the president can use military force without checking in with Congress. And there are very specific components to compliance with the War Powers Resolution. They include, and they're here, but I'm not sure I'll be able to read them from the slide. Ability of the commander-in-chief to send in troops in 3 situations. And so those are the 1, 2, 3 here on this slide. It requires the president to consult with Congress in all possible situations within 48 hours. So you send the troops, then you send something to Congress saying what you did within 48 hours. And this is Congress saying we should be a check on your use of your commander-in-chief power. No part of this federal government gets to be a tyrant. No one acts alone. So we're trying to be a check on what you're doing. Requires the withdrawal of troops within 60 days unless Congress approves the use of force. So you can act affirmatively, but you got to come back and comply with reporting according to Congress for it to be a constitutional use of power. And it gives a 30-day extension if there is an inability of Congress to meet because of a national emergency. So that's what the War Powers Resolution is. It sets forth these details and this reporting asked of the president. Now, whether it's constitutional, people disagree with. It's never gone to the Supreme Court. As I've told you about the court, this would be the last thing they want to stick their noses into, right? They want to stay out of controversy, so they have never taken a case on the constitutionality of the War Powers Act. Some presidents have challenged it. No president, once they become president, wants to decrease presidential power. Again, even presidents like Barack Obama, who were professors of constitutional law, and even a professor who taught at my law school, who went on to advise President Obama, who's an expert in the field of presidential power and had long written about how constrained it should be. When you get in the executive branch and you start advising folks, the practice becomes a little different than theory. And so that's why presidential power is so hard to constrain, because no matter who you are in the White House, your belief is you're exercising it for right often, and you believe that having more executive power is for the greater good. So again, it's left to Article 1, Article 3, and the people to be the check on the president. Presidents don't
check themselves. So that's why there's often a willingness. President Obama and many presidents before him have complied with the War Powers Resolution. They'll send in the reports, but when push comes to shove, many presidents will still say, I'm kind of doing it voluntarily. There's not been a recognition that they somehow have to do that. The other kinds of checks we have on the power of the president, private lawsuits against a U.S. president. Can a U.S. president be sued by a private person? Yes, no, a little bit of both, okay. Trick question, yes and no. Can a U.S., you're both right. Can a U.S. president be sued by a private person? Yes, for prior actions. Things you did before you were sitting in the office of president. No for actions during that are in your official capacity. I should add that, and I do in a later slide. So can a U.S. president be sued for non-criminal civil violations of law for actions taken while serving as president? No. This was President Nixon again. The president had an absolute immunity, complete protection from civil lawsuit for all official actions taken while in office. So something you did as president that harmed people, which we can imagine there would be a lot of things that could fall into that category, even if you're a very well-intentioned president. And so in Nixon versus Fitzgerald, this is where the court went through that process. U.S. president cannot be sued while holding office for a violation of civil law for official actions taken while in office in official capacity. This is my commentary in red. This holding leaves open criminal prosecution of a U.S. president while holding office of the president for crimes committed prior to and while president. I've added that. I mean, now we're all wondering what would happen if President Trump shot one of us in the middle of Fifth Avenue. Would he be prosecuted? There's not a case on that in the Supreme Court Reporter, but I have also already given you a foundation for him not having unlimited power, right? Nobody in the federal government has unlimited power, and we do have the precedent of U.S. versus Nixon that I just described that said in the context of being asked to comply with a federal judicial subpoena, if it's a criminal prosecution, you have to comply. So you can imagine how you're already ready at Thanksgiving dinner to make your argument that if it's a crime, that maybe there would be an opportunity to prosecute. And if it weren't while the president was in office, certainly after he left office. So, but there is not even in this case an immunity for civil liability for unofficial actions taken while in office. So I want to put that out there too. So even if you do something short of a crime as president, there's not clarity as to whether you would be immune from being sued civilly if what you were doing was on your free time, like while you were just golfing or on vacation for something. And everybody golfed. I'm not necessarily just talking about President Clinton. We've had a lot of golfing presidents. So it's a long-standing and unstated presumption that I'm just adding here that the president can be prosecuted for crimes. I'm just saying that that's my reading of how the whole Constitution works, that to the extent we don't have a government of kings, and we didn't want a king, and that was the framers' key point, then you wouldn't have someone who could commit a crime without there being some check. I don't have a particular ruling to point to on that, and that's fortunately because we haven't had a president that committed a crime. So again, it's not to say that the absence of the ruling proves that the power exists. So can a U.S. president be sued for actions taken prior to serving as president? Yes. I showed the yes? Maybe there wasn't even a question. Okay, see, we're getting to the end of the semester. I'm like, yeah, let me just give it to you. Everybody's tired. Class is coming to an end. Clinton versus Jones. President Clinton does not have immunity from lawsuits for acts that occur before a president takes office. The private citizen seeking to recover damages. This case, and I've highlighted what was at issue. Clinton, when he was a governor, delivered a speech at a conference, and Paula Jones was staffing the conference, said she was asked to visit his business suite where he made, this is according to the Supreme Court, abhorrent sexual advances that she vehemently rejected. Just to be clear so we can remember the nature of what was being litigated. And a private citizen was able to sue a sitting president over this because it was something that had happened before he came into office. And it rejects the argument that a civil lawsuit against a U.S. president must be delayed because that was Clinton's argument. Not that he could always be immune, but that he could delay the trial or the trial until after his term ended. So you can be sued while in office for actions taken prior to serving as president. What we do in law is we give you the narrow ruling. Are there other implications from the analysis that you could draw? Absolutely. The beauty of information today is you don't have to have a law library and your own FSUPs to go look up cases. You can read them yourself and reach your own conclusion about what also might be inferred from the analysis. Can a U.S. president be criminally prosecuted while in office? We've heard this so many times in the modern discourse about memos in the administrative branch of the federal government. So let me be clear, as a matter of constitutional law, I've said the Supreme Court has not ruled on this question, but I think you could find a lot in the cases, including U.S. versus Nixon, that would suggest that you absolutely could be prosecuted. But we don't know if the court would ever take that case, because that would put the court in a very awkward position. We're rounding the bend here. Impeachment. I'm really giving easy ones now. Can the U.S. president be impeached? An easy one, right? Articles of impeachment for President Nixon, since he wasn't impeached by the entire House of Representatives. These are just, and it's way too small to see, but it's just kind of giving us a gestalt about it. The House Judiciary Committee passed these articles of impeachment. So this is the Judiciary Committee, and he resigned before the full House of Representatives voted. But he was impeached for obstruction of justice, concealing, covering up evidence related to the Watergate break-ins, making false and misleading statements to the government and the people, withholding information. See, there you go, lying to the people. Withholding information, encouraging witnesses to give false or misleading statements, attempting to interfere with the FBI or other investigations into the break-ins. Those are the kinds of things that were in Impeachment Article 1, which led him to resign. Impeachment Article 2, using government agencies improperly. Impeachment Article 3, failing to comply with subpoenas. President Clinton, the articles of impeachment for President Clinton, perjury before a grand jury. This was over, some of you may remember, and I didn't, it was a little too lurid even for drinks, right? No, it wasn't that lurid. It's just that the details of what President Clinton lied about related to the character and nature of the sexual intimacy he engaged with Monica Lewinsky, an intern, while he was president. Did he lie, and the extent to which he lied, during Paula Jones's civil lawsuit? That's the other thing. Why was he testifying in the first place? It was the Clinton versus Jones lawsuit that put President Clinton under oath. And he was asked during the deposition in that lawsuit about other dalliances, cheating, whatever kind of things we wanted to say about the way President Clinton was behaving, or then Governor Clinton. And so that's how he got under oath, being asked about his relationship with Monica Lewinsky. Ken Starr had been tipped. And again, let's take some of us down memory lane, and others will need to go home and Google it tonight. But there was a lady, Linda Tripp, who was a confidant of intern Monica Lewinsky, to whom she had confided that she had this relationship with the President of the United States. I guess it was just a secret too big to keep, and Linda Tripp told. And so Ken Starr got that information. Bill Clinton was caught like a deer in headlights. He's like answering, but he said he was making a distinction between other kinds of sex and the kind of sex he had had, oral sex with Monica Lewinsky, and that's how he said things that were unclear, and then he went before a grand jury, and then the argument was that he had been less than truthful, or he had obstructed justice, or he hadn't said so explicitly. And what I love is there is actually a page in my con law book that I was tempted to put in here, but I guess I just, time and also we can all Google it, but it's the Q&A about actually what he said. So this is the minutia we were getting into that led to President Clinton being impeached. The perjury before the grand jury was about how he characterized the intimacy. Perjury in the Paula Jones case, that's 2. Impeachment Article 3, obstruction of justice. Again, all related to this involvement with Monica Lewinsky. And then an abuse of power, charging the president with making misleading statements for the purpose of deceiving the people of the United States. And so to the extent that you hear some commentary about the Federalist Papers and what Alexander Hamilton had in mind about impeachment, this is kind of circling back. He talked a lot about a concern for an action by the president that violated the public trust. So for some, maybe you could say, well, it's very important that the president not lie about what kind of sex he has had, or if there's one day a woman, what kind of sex she has had. But there's also a strong argument that when you read the Federalist Papers in their entirety and you think about the Constitution as a whole and the themes that the framers came back to over and over again, they were exceedingly concerned about a president that could be essentially in the pockets of or beholden to or on the take from foreigners, from other nations, that they would be corrupt in a way that would undermine our freedom, that they could be corrupt in a way that could one day put us under the boot of a tyrant, as a dictator at some point. So that's the argument for those who think, oh, well, it makes sense that this guy actually didn't get removed from office as president. Maybe it was okay to give him a hand slap for lying, but to actually remove him, there were Republicans who voted failed to vote to remove President Clinton, and Democrats on the other side, so people crossed party lines a bit. But on Article 1, perjury before the grand jury, and Article 3, obstruction of justice, those articles passed by a majority of the House, but they both failed to receive a 2/3 vote in the Senate. So therefore, President Clinton was not convicted and not removed. Article 2 and Article 4 did not gain a majority in even the House of Representatives, so he was not impeached on those articles. So I will leave it there. That's a whole lot to have left you with, but it's been a real pleasure to do Constitutional Happy Hour, and again, I commend all of you for taking the time to engage in such an important topic at this late hour in the evening.
So now the floor is open for questions, and if people want to share experiences with Article 2, the floor is yours.
Thank you so much for this brilliant talk. I have two short questions. Number one, don't we have the right to face our accusers? So will this government will request to face the whistleblower? And the other question is, due to what happened in the past to the President Bill Clinton, history repeats himself. Could we have the same thing? Thank you.
Repeat the last question about Bill Clinton. Go ahead.
Okay. Due to what happened in the past with President Bill Clinton, he was not removed from office.
Right.
Could this happen again with President Donald Trump, that although they will go through all these procedures, that he won't be removed from office?
Absolutely. So I'll answer the second question first, because we have never had a U.S. president removed from office. We've had only 2 impeached, because even Nixon was not impeached. And so it is absolutely possible, many think it is quite probable, that the current U.S. Senate will not vote to convict President Trump. I would say that that's disheartening to me as a scholar of constitutional law, in the sense of I believe that us complying with the Constitution is for a greater goal than partisan goals. That what I hope I've left you with tonight is that the Constitution is for everyone, no matter what your political affiliation is, and it's about what distinguishes us from countries where you're not free to dislike, critique, speak ill of the president, whomever it's so far been he is, and that's something, depending upon who's in the White House, all of us should feel very strongly about, that we can amongst ourselves here at this table not be afraid that the person across from us could go tell some government entity, and then we not wake up the next day or something horrific. And this is not hyperbole. I was here at the museum for another event, and the last question was, what keeps you up at night as a constitutional law scholar? And I'm like, really, fear of tyranny. I am really afraid of no longer living in a free government. And so how that relates to the vote on impeachment is I would hope that people who have sworn their oath to the Constitution would, at a trial over the propriety of actions of the U.S. president, would listen to the evidence and decide based on the evidence whether or not it's appropriate to remove the president or not. Now, so we shouldn't have, before you go to the trial, that would be like jurors saying in advance, there's no way I'm going to vote to convict. But so it's absolutely possible, because we have a lot of evidence based on statements that people have made that they may be in a position where they're not going to vote to convict this president or remove him, no matter what they hear he has done. On the first question about being able to address your accusers, I would say that it's not in my area of law, but in just basic criminal law, when you're at a grand jury stage, you don't get to face your accusers. That as the prosecutorial arm of the state is gathering evidence and meeting with witnesses, that happens out of your purview and it happens in secret. So in a broad general sense, you do not, and then in really specific senses, because there's no absolute rights to anything, as I just said, there can be all sorts of exceptions to virtually every rule. So that's the con law professor answer you get. It's never a straight yes or no. So sometimes you get to face your accusers, and other times you do not. Okay.
Excuse me. When we're talking about these powers and the checks and balances on the powers and the growing of executive power, and how the citizenry is not seeming to be engaged with holding their congressmen accountable, to holding the president accountable or the executive office accountable. It seems to me like, at least, and this is probably just due to my exposure as well, since Bush era, you've had a lot of covering up of information such as the CIA black sites, as well as the drone program, and to the extent at which the drone program was killing civilians during Obama's administration as well. When so much information is kept from the public during the presidencies of these people, how are we ever supposed to make informed decisions to try to check these powers at the time that they're being completely abused?
So it's an excellent question, and it goes to, again, why our freedom and liberty is so critical to the kind of country we have, that the only way we typically get information about things members of the federal government or people in the federal government don't want us to know is through the press, right? It's through whistleblowers. Whistleblowers were brought up. That you're absolutely right, there's not a good way for us to know. And that's why we all should have a vested interest in freedom of the press and access to Freedom of Information Act, and why we want to continue to have the government be open and free. But at the same time, prior to President Trump's presidency, it has long-standing been a part of my constitutional law classes, and pretty much in almost any, well, not any, because some just have the cases and don't say anything, and they just leave the poor students to figure it out. But in my constitutional law casebook, there's commentary that tries to point out to students that, again, as I said, and you just acknowledged, that it's not a partisan, we can't say it's only Republican presidents or only Democratic presidents that have increased presidential power. And one example that is a good one is President Obama's use of drones. But we knew about that. We did. We knew he was exercising the power to kill other human beings without any sort of judicial process.
Right, but the degree to which civilian deaths were... Sorry. I was saying the degree to which the civilian deaths were being reported and how they went about counting civilian lives hasn't come out until, the past few years.
Right. And so I am agreeing with you on the point of we did not know the exact nature, and that makes it worse. And this is the challenges of this document, right? This document does not protect us from all that much. I mean, I get to a point where I say, if your question is how do you serve as a check on the executive branch when they can keep things secret from you, it's a tough one, right? We don't have anything other than some members of Congress might file a lawsuit, ask for the information. You hope the Supreme Court's going to rule. You hope that the press is going to get involved. When we do find out, you make a ruckus about it. protesting. I mean, there's really not a lot. You vote, you protest, and then the other thing is you run for office, for either president or a member of Congress, so you can be there to be the check. And and that's what I believe would be helpful. Like if we had fewer people who were trying to be in Congress for long periods of time, that if we could have citizens that were like, okay, we got a day job, I'll go in there for a couple of terms or maybe just one term, and I will do everything that is morally, in my view, right, and then I'm out of there, right? That we don't have a lot. And this is why many have been critical of this Constitution. It's an elegant document, but it's an old one. And there are more modern constitutions that have more explicit checks. But the other problem is if we start fiddling with this thing, people get kind of fearful of what might happen. So I don't have a simple question other than run for Congress so you can be the personal check on the president.
I want to first thank you because I think you must be an excellent professor.
Oh, that's so kind of you.
Because we've learned so much already. I have two unrelated questions. One is, you mentioned none of the branches of government have police power, so I wanted to understand a little bit better if you could explain the power that is invested in ICE and if that is constitutional. And another question that may be a little easier, do you anticipate that there will be more Supreme Court cases decided in the area of executive power during this administration?
Okay, I'll again do the second one first because I've already predicted on that particular point, and my answer is no, because there's the fear, I would assume, that you have a president you can't predict, and a president that has Andrew Jackson on his wall. And so a president who's renowned for not complying with the Supreme Court. So if you've got a strategist like Chief Justice Roberts on the court, he's not going to want to get in a showdown with someone who isn't vested in the overall constitutional structure. For someone like Chief Justice Roberts, for me, for a lot of people, the Supreme Court, and my students, as much as they have very little positive to say about the Supreme Court, the minute you talk about adding justices or the Supreme Court being ignored, everyone gets very riled up, and we should, because it's all part of the tripartite structure, right? We need the court to be a check on those other two branches, so no matter how much disdain we have for any of the three branches, if we lose one of them, then we're all in trouble. So that would be the argument for why we should even commend the court for staying out of the fray, because if they overstep and we get into a situation where President Trump doesn't comply, then that phrase that people have been throwing around, we have hit constitutional crisis. Like we are at constitutional crisis, DEFCON, I don't know how the DEFCONs go, whatever the bad one is, that we're there. So that's why I don't think they're in a hurry. And we've seen that with the Muslim ban versus, travel ban, whichever terminology you like to say with those cases. This is how you keep seeing the court giving the Trump administration 2 and 3 and 4 bites at the apple, like one more time and do it truthfully this time. I mean, they are really trying everything, in my mind, not to get into a battle. On the first question, it really becomes kind of a term of art, wonky sort of constitutional law terminology piece. So this idea of a police power, I'm putting it in quotation marks because it's very much a term of art. It's just something the court has used to refer to states as governments that don't have to prove that they have the power to do something as a matter of constitutional law. Your state constitution could still require Governor Newsom to have power before he does something. But if you want to sue Governor Newsom for an action and you want to sue him over violating the U.S. Constitution, he doesn't have to prove that the law that he signed or that the California legislature passed was within the power of the state to pass. You can only sue him for violating the 14th Amendment or some other provision of the Constitution. Why this is so specifically about the federal Constitution, and why I went to the trouble and why I think it's always important to think about its different parts. When it was originally conceived, it was all about creating this new federal government. And it was all about, including the Bill of Rights, limiting their power. And I always say, we're talking about the powdered wig framers, not the Reconstruction Congress post-Civil War framers. Those guys were concerned about King George. So when they created the federal government, it's a government of limited yet supreme power. So this is where the Supremacy Clause comes in, and where there are realms of authority that the court has said belongs to the federal government. And that was part of creating the new federal government structure. Much like we want the federal government to decide what Commerce Clause rules are going to be, what tariff rules we're going to have, the same for immigration. If they're conceiving of this new federal government, you leave it to the Congress with the check of the president, who's got to sign laws. So any immigration rules and laws we have, presumably there's a check on them, right? If the president has ICE to do X, Y, or Z, the judiciary's a check, and Congress, if they don't like it, could pass a law that says, no, ICE can't do this or that. So with that said, there's still a deference in certain areas, and immigration becomes one of them, because if you think about which of the governments, state or federal, you'd want to give the power to decide immigration rules to, you would give it to the federal government, because you don't want North Carolina and New York to have different immigration rules, or California and New York. And so that is, again, the term police power is really a term of art, and I don't want to suggest it should be overread, because the reality is we have a very extensive federal criminal law, and we have an FBI, and we have all sorts of ways in which the federal government both enacts crimes and executes and prosecutes us for crimes. So there are different things, but it's a really good question.
Yes, my turn.
Okay. Hi there.
First of all, thank you for a very, very interesting lecture.
Oh, fabulous.
I come from across the pond,
Fabulous.
and there are two questions I'd like to ask you. Regarding the separation of powers, and when the Constitution was put together, and the federal Constitution was put together, parties were not that important. Parties, the Republican Party and the Democrats are the only two in this country. I come from somewhere where there are two as well, important ones. But never before has partisanship and tribalism, this is my view from looking across the pond, been so prevalent in this country between the Republicans and the Democrats. So against that background, the question is this: are the separation of powers being undermined by a tribal loyalty, be it Republican or Democrat, and I'm thinking more of Republican at the moment, being present in each of those three components? Congress, the President, and the Judiciary. Now, as far as the Judiciary is concerned, the Supreme Court, I'm amazed, coming from across the pond, that any person who has a political point of view could get anywhere near the Supreme Court, because the whole point of a judiciary is they're supposed to be independent. So, question, have the separation of powers been undermined by the recent tribalism, partisanship in the parties? Because the original founders didn't have parties in mind. All they were looking at across to the old world was monarchies. No political parties really at that point. Second question, justiciability. We recently had back in England, I say England, I should say Britain, a case involving the prorogation of Parliament that went to what we now call the Supreme Court, used to be the House of Lords. And there they used a device, two devices. Judicial review, which doesn't seem very developed in this country, and giving a purposive construction to the law. So when you said non-justiciability, isn't the answer to that you apply judicial review principles? Is the power exercised rational? For example, does it derive its power? Does it derive its authority from a particular statutory provision? Is it partisan, for example? So there are ways of controlling executive power by way of what we call judicial review, which I don't see being exercised. I'm sorry, I've taken too long.
Okay, so I'll take the last one first again. It's a theme, which is I'm not here on the Judicial Power night. Otherwise, you would have gotten the Power of Judicial Review lecture. And a key, the first topic I cover in constitutional law is the judicial power. And I say repeatedly, I said that I wasn't used to this kind, I'm the lapel kind, but first time for everything, I'm working on it. I say over and over again, it's an awesome power. Awesome because who wouldn't want to exercise it if you're a judge? I mean, if you're a lawyer, everybody wants to be a Supreme Court justice. It's an awesome power in just that sense, like awesome. But then it's awesome because it's awe-inspiring how extreme and significant the Supreme Court's power is. And it's extreme and significant because we do have the power of judicial review. And in the most famous case in constitutional law, the one we do either first day of class, we read it, maybe, depends on if I'm being nice, they just get the Constitution. Sometimes they get the Constitution and some of Marbury versus Madison. But the upshot in that case is that the Supreme Court declares an action of both the president, or at least his Secretary of State, and that's James Madison, and an action of the Congress unconstitutional. And does it in a brilliant way, because all remember this guy has is the power of the pen. The way he does it is he doesn't order anything to happen. Thomas Jefferson's like, oh my gosh, that Chief Justice Marshall, I'd like to strangle him, but I can't do anything because he didn't ask me to do anything. Like he just put it all in the opinion and gave himself, or the Supreme Court, the power of judicial review. So awesome power, brilliant way to do it. And the way they kept it is they didn't use it. They didn't strike down any federal laws until Dred Scott versus Sanford. And so when they made their move, they did it in a terrible case and did it in a terrible way that's embarrassed them from then on. But getting the power was brilliant. But the key about that power, and what I'm telling you about their failure to exercise, is it is highly discretionary. So that's also awesome. You got the most powerful, fabulous job, and you get to do it only when you want. They don't have to hear any cases they don't want to hear. They set their own rules. They hear only a fraction of the cases that come out of the Court of Appeals. And then they read into Article 3, another thing, you're like, yeah, because I could give you guys the whole semester, right? We just stay here till, tomorrow, right? And we do it all. But Article 3, they are interpreting an ambiguous provision in Article 3 as their grounds for having this. They say we have justiciability is just the power to decide. And then they, in a series of cases, tell us there are limits on their power to decide. But as I say about justiciabilities, they're judge-made limits. Great job. You have this great power, and they didn't just make it up. It exists in England. It was in the Federalist Papers. So the power of judicial review was pretty much assumed. But it had to be interpreted into the Constitution. But the piece about we don't have to hear any cases we don't want to hear is something they held. It's something they came up with. And who can tell them they're not right? I mean, we really don't have a mechanism for it. So it's not for lack of them. They don't want to hear these cases. That's what's really clear when you evaluate the justiciability doctrine. It's what I'm saying, that they're opting not to exercise their power of judicial review. On the parties front, I'm not going to purport to be a historian, but I am the constitutional law professor and the expert in the field of what I tell my students. And so the point about partisanship is a hard one to make, hard one for me to agree with because of even just Marbury versus Madison. They just had different names. But the Federalists and the Anti-Federalists were the two parties in Marbury versus Madison. And the sitting president was at such odds with the Anti-Federalist that he appointed the midnight judges. I mean, his inauguration is like, days away. He's appointing judges, packing the Supreme Court with his party, which is Federalist. Thomas Jefferson is coming in. He's an anti-federalist, or actually an agrarian Republican, just to demonstrate we had all different names then, and it's like that's super confusing. It's not the Republicans of today. But we've had Whigs, we've had all sorts of parties, and we've had members of Congress literally caning each other in Congress on the floor of the House. And so as bad as it is, The historians keep telling us, oh, we've been to worse and more partisan places. So that's a specific response to whether it's partisanship that it's issue. But I guess I would agree with you and kind of trying to wrap up the answer that I'm appealing to, as again, the professor of constitutional law, to honestly patriotism, to honestly an allegiance to the Constitution. And I'm appealing and would say that no matter what party you are, you took an oath to the U.S. Constitution. And I haven't said this in public. I've said it to enough people that I'll say it. And only a con law professor would think this is really radical. But I think it's an impeachable offense for you not to do your job when you sit and hear the trial on the President of the United States. If you tell me beforehand you're not going to listen to the evidence and you intend to just vote based on party lines or because you like the guy or you want to get reelected, in my mind, then you violated your oath of office, and that's got to be a misdemeanor. You guys are nice. I got to tell my students to clap. That's going to be the best part. They clap on the last day. When it's all over, I get the end of the semester clap.
Hi, I think it's my turn.
I'm going
I'm
by
over here.
microphones.
I think
Okay,
it's my
sorry.
turn.
So it's not that I don't see your arms. I've been instructed. People have the microphone.
So I also have two questions, and they're kind of broadly just out of frustration, okay? And one of them is the fact that President Trump has lied repeatedly since he took office. Isn't that treason? I don't know how he's getting away with all the lies, the legitimate lies that he's telling the people. And my second question is, can you talk about the preamble for like just a moment? Because general welfare, posterity, I mean, I don't understand how policy can go against what that is. And has that ever been brought up to the court?
I'm so glad you brought it up because Claudia actually said that's something that has been brought up on other nights, and I didn't bring it up, being a complete constitutional law geek, because scholars of constitutional law and the U.S. Supreme Court never interpret the preamble. They never treat it as a part of the Constitution that confers any rights or warrants any sort of... Well, this is back to the power of judicial review. Like, I can write a law review article and tell them they should, but it's all about their theory. We're not going to theories of constitutional interpretation, what has been precedent. As a matter of precedent, the court has never looked to the preamble. You have justices on the Supreme Court who, like Justice Ginsburg, will give speeches and talk about we the people and say how there's been a change in who counts in we the people. But I can't point to any Supreme Court case where the court has said things that are said in the preamble guarantee a particular set of rights. In general, we have a constitution that has been interpreted over and over again to be a constitution that protects us from... We have essentially negative rights. We have the right not to have the government do things to us, but we don't. And it's not for lack of people arguing it. There have been multiple cases that have gone to the court over the years and over the decades where claims have been made that we should in this country have rights to various things, like just basic health care or food, shelter, and clothing. But that is in some other constitutions. When I say ours is kind of an old one now, there are constitutions in the world that have those affirmative rights textually committed in the document. But since we don't have them, it is that power, again, the federal judiciary and what those judges have over time held. Who controls that? I'm kind of going back to the really important role the people play. Who we elect to the presidency is who gets to a point who goes in the Supreme Court. So if somehow we could have a groundswell of Americans, and then we'd have to have a scenario where we had that scenario, right? Like if you don't like what the current court uses as its approach to constitutional interpretation, it would have been last election where that would have meant the most because we've had 2 justices added to the Supreme Court, and it's going to change what the court does going forward. But we, the people, still have some say in... We, the people... Still, arguably, we have some say. But it is not a direct engagement. I mean, that is a key problem with what I'm describing as our structure. It's elegant, but we don't have, there's not a lot of direct control over something like the preamble. On the question about President Trump and lying and treason, I would say that I probably am of the mind that treason is more of a term of art. In fact, I am pretty sure one night was dedicated to just treason here in this series. And actually, it was a colleague of mine who was here talking about treason. I don't think we have to go that far in the sense of if your concern is, and I think it's a very valid concern, so we need truth, we need accuracy from the presidency. That is part of holding an office of public trust, is being truthful. But that would be impeachable. I mean, we've had that happen before. It is already, as a matter of historical precedent to say that lying to the American public, in Nixon's case about something that was very harmful and related to covering up a crime, and while he wasn't actually impeached for it, but it was part of the process, being impeached for lying would seem to be well within what could be possible. So committing impeachable offenses and actually being impeached are two different matters. And sadly, I think just as a matter of descriptive reality, President Trump was impeachable from the moment he took office for the emoluments he's taken. But that's different and distinct from having a majority of the House of Representatives impeach. And why? Because again, who has the biggest check on everyone? We the people. And so if we don't have a majority of the people behind impeachment, we couldn't get to the point where the House of Representatives would act on these many theoretically and probably doctrinally impeachable offenses.
So on that point, I also have two questions, but I'll be very quick. One is, on the point of the people having the ability to be that check, can you talk a little bit about Equal Protection Clause as it relates to campaign finance reform and districting reform, since our ability to actually effectuate that check is highly limited in an area where electeds can often choose their voters? And then the second is, since you brought up constitutional crises, can you talk a little bit about the hypothetical of what happens if President Trump loses and refuses to leave office?
Oh, goodness, no. I mean, I can. There's no case law. There's no case law. We'll be in dangerous territory. We'd be in territory that the framers would have, had nightmares about. That is literally someone unelected thinking I can just stay in office. So I hope it doesn't come to that. I hope that somehow we have checks to keep that from happening, although they're not textual checks. You can read this whole document and it's not going to be textually there. With respect to the court's recent decision saying that partisan gerrymandering, extremely partisan gerrymandering that could, in fact, essentially disenfranchise people if they aren't in the party if the other party drew the lines for voting, is non-justiciable. That's what the Supreme Court said. So they didn't say it was constitutional. They just said, we can't decide. And it is probably the most important decision the court will have decided maybe this half century, maybe this century. We don't know what's going to happen. But there's not a lot you can do. I mean, there's certain areas where the court has power, and that power of judicial review includes that power not to decide. And so as far as where people who are concerned about that reality are turning, they're turning to state courts. So that's kind of the short answer, that there's not a way to change that, because the composition of the court is not expected to change in any way that would make revisiting that ruling and getting it back to the court. They're not going to change their minds. We don't have any reason to think they would. The Equal Protection Clause writ large is probably a whole nother topic, but Citizens United and just that concern about money in politics, that is often a case that many people see as a one-off case, that the court's holding one thing, and a legislative fix is probably probably a better answer to most of these things. And as far as like giving you something that you can feel empowered about as citizens, many of the things the Supreme Court does that are in the realm of voting could be rectified with, power of the people. Go get elected, elect the people who believe the things you believe to Congress, and then they can pass a law. And so you can get a legislative fix to Citizens United, and you could get a legislative fix to the partisan gerrymandering case too. We're back to, do we have enough people in the United States of America who feel similarly that we could get enough people in Congress to do a legislative fix?
I have a question about executive power, a case that's coming up on the 12th of this month before the Supreme Court. That's going to affect about 1 million DACA students now who have work cards and so on. I know President Obama was roundly criticized for exceeding his executive powers when he announced that program. But I also know that in the last year, or the last couple of years, the Supreme Court has okayed Travel Ban 3 by President Trump. And then more recently, they've lifted the injunction on the remain in Mexico. You have to stay in a foreign country while you apply for asylum, something that I've never seen before. So the Supreme Court, on one hand, seems to be giving the president very, very wide powers, the current administration, over immigration. And I just wonder, how do you see that affecting how they're going to come out on DACA? I mean, I'd like to think the Supreme Court's just not, partisan lackeys for what party appointed them. But I am a little worried that they'll find some way to say, well, President, despite what we ruled about the travel ban and that remain in Mexico, we don't really think that the former president had the power to announce the DACA program.
I was going to go back to my diagram I love. So it's a question about what's in this box, what kind of power the president has. And when it was President Obama exerting the power or creating a deferred action for childhood arrivals, you're right, he was criticized for, we try to use a fancy word again for everybody to get their tuition worth, for usurping, taking the power of the legislative branch. That creating laws about who can enter the country seems more like making law than executing law. So that's the grounds for the critique of President Obama. And this is also the foundation for how we can let executive power bulge, slip, or slide, or we're okay with it if we agree with the underlying policy. We're like, well, President Obama exercised his use of drone power in a way that made us feel safer and objectively made the world a safer place. If you believe that to be true, you're less inclined to want to vote him out of office because of how he exercised his power, but yet you'd still have, and this is how you can be geeked out on a Friday night and go, we're doing good work. We should still have the conversation. Because one, he's not a king, and even if you love him, he's not going to be president forever. And even if you do love him, he still could be getting outside of his box. So the answer that I have about what we're seeing with the current Supreme Court and what my expectations would be is, and it kind of reminded me that I didn't really address the very important and substantive concern about judges being partisan. You both are raising it. They're not supposed to be, even if they have partisan affiliations. Part of what I have I've been teaching constitutional law like over 15 years now. And so early in the years, I could kind of play along and go, yeah, they get up every morning, look in the mirror, and they try their best to be objective, and none of us can be wholly objective, but they're doing their best. But kind of what I'm not having a personal conversation with them, but what I needed as far as that working, for me not to sound like the most crazy Pollyanna person in the world, is for them to keep their mouths shut. I don't want to know, I don't want you to tell what kind of news you watch. and this didn't get good looks in my seminar one time when I said, and I don't need RBG saying Trump's an idiot and he shouldn't do X, Y, and Z. I'm not disagreeing or saying what, the point is you don't get to say that because you've got the awesome power of being a justice on the U.S. Supreme Court. You're not supposed to be partisan. You're at least supposed to give us the appearance of fairness, and you're not in it for party. And then we go read your opinions and evaluate whether you apply your theories consistently, and we law professors argue about it, our students argue about it, wonderful people who come on Friday night to talk about constitutional law. We can disagree and say, well, no, you're reading his opinion wrong or her opinion wrong. But if they come out and tell us they watch Fox News or they go on trips with certain partisan people, or they say extremely egregiously partisan things in their confirmation hearing, it's beyond the pale. I mean, law professors across the country are like, we don't know what to do. Like, our law students aren't even allowed to talk that way. I've said about my own federal judge, who, if you look him up, he was the liberal lion. People would mock him as some idea that he was so extreme and results-oriented. And that wasn't my personal experience with him. I mean, he worked we were there till 2 in the morning, and we're so tired, Judge, and, sorry, we're 40 years your junior. But he would never have spoken to us in the break room in such a partisan manner. And so I'm very disheartened by what we've seen, and it's a real problem for the court's integrity because their power, these people here, rest with us believing in them and believing they're nonpartisan. And that's a whole other part of constitutional law, because if we start to lose faith in them, then when people threaten to pack them and say, hey, we'd like 5 more who are more principled than you, no one's going to stand up for them. No one's going to say, yeah, they're really nonpartisan and fair, because we won't believe it. And so no matter who's there, I'm vested in them not coming off as partisan. So I'm kind of more answering that question. The thing about the power to control immigration is it's really a federal government power. I mean, that is one of the areas where President Trump and the Trump administration is on their strongest footing as a matter of power. And when you're exercising power, with that comes discretion. It's like the pardon power. So if President Obama pardons someone, he's acting within his power. President Trump pardons someone, he's acting within his power. President Obama, if you think he had the power to enact DACA or sign DACA, he can't enact it. Remember, that's the critique, right? Only Congress can pass a law. I'm just a bill sitting on Capitol Hill. He's got to sign it. But he puts an executive order out. Trump has all the discretion, I would think, to change his mind on that policy matter, because policy is what's at issue. And that's what makes this case really tremendously impactful for people's lives, right? I mean, you're right about this being a tremendously important case. It's not clear what the legal grounds would be if the Trump administration had simply gone to court and said, we have the power to do this. My understanding of how the case has presented itself is they have said, not that we have the power to reverse President Obama, but that what President Obama did was illegal, and we're reversing it because it's illegal. And so they've created a unique grounds. And again, it just kind of seems like, honestly, bad lawyering. Like, it's just not a good grounds. And maybe that will mean if you are in favor as a policy matter of DACA, that might be a route that the Supreme Court might take. But again, whether it's partisan or not, I hope the court, and that's just, if they've lost their integrity, they've lost their integrity. But when they write their reasons on the page in the opinions, they tell us something other than who appointed them. They give us a reason. And so that's, again, the beauty, I think, of where we are in this moment of information. We'll all probably get the opinion about the same time. We all read it. I always encourage my students, again, if they're at Thanksgiving dinner with you, I hope they'd encourage you too. It's all of our Constitution. It belongs to all of us. The court works for us. The president works for us. Congress works for us. Read their opinions. If you're not persuaded, if at the end of them you read it and go, they're a bunch of partisan hacks, then they didn't do their job, because their job is to convince you that they are interpreting the law, and they're not making law, and that's what we'll be looking for in that opinion. But as far as just the grounds of exercising judicial power, again, I think when it comes to executive orders, that's the problem with doing things by executive order. You're exercising presidential power, and then when the next president comes in, they can exercise their presidential power to change it back.
If they are partisan, there's nothing we can do about it.
If they are partisan, there's nothing we can do about it, meaning the Supreme Court? There is a challenge, right? Samuel Chase, a member of the early Supreme Court justice, was impeached, and we kind of have a historical precedent for not impeaching justices on the Supreme Court for their decisions. So there's, but as far as the check on the judiciary, the check we have on the judiciary is impeachment. And the fact that the Constitution does not delineate the number of justices. So there is not a constitutional barrier to adding justices to the court. So they live with that threat that the Congress could change and decide to add justices.
We have two last questions, and before we get to the final two questions, I just want to say the bar is going to be closing shortly, so if you'd like to grab another drink, this is the good time to do it. And now here is our second to last question.
I'd like to join everyone in thanking you for this wonderful lecture. It was great
I love
tonight.
it. Thank you. You're welcome.
When seeking to impeach a president, wouldn't you want to limit the scope of your investigation to avoid what happened in the Clinton case where some of the articles passed and others didn't? And what is the legality behind that? Secondly, could you expand on what your theory would be on any constitutional defense available if a president such as Trump or Nixon decided not to leave office, even if it's just a theory that you had? Thank you for asking that question. That's what I was thinking.
Oh, my goodness. It's beyond theory. It would be, I mean, if Congress needs to pass a law to make it a crime, maybe they should. I mean, if we get to the point where we really feel that that is possible, that would be what I would think should happen. You know, again, there's something really broken, not in a partisan way, but if we think that Mitch McConnell wouldn't sign on to a law like that, like then we've just gone to a place where we've given up everything this country's supposed to be about, right? Like, we will cease to be a free country if that happens, and the Congress doesn't do something about it, and the Supreme Court doesn't do something about it. But I don't think we need a law for that. I think there are many things that are easily interpreted into the Constitution implicitly. You don't need to have the actual text say that for it to be wholly and completely unconstitutional. There's just no other way. And I guess the text of it would be that, you know, you have a term, and when it's over, you leave. I mean, I think we'd have a textual support for it as well. So as far as what the extraordinary actions would be, now we're kind of getting beyond constitutional law to kind of like what would need to be done in that political moment. And I feel like your other question kind of falls into that category too, in the sense of, you're asking a political strategy question, and I didn't bring that slide, but I have a slide where I'm like, the legal theory, legal doctrine, and then public policy, morality, different things. And I say we talk about those things in law school and in constitutional law, but one of the things I want everybody to be clear on is when there's a distinction, and I don't have time usually to talk too much about public policy. I'm like, it's not public policy school, so we'll study legal theory, we'll study legal doctrine, and then we can kind of talk policy in the break. So just to be clear, this would be kind of a let's talk about it at break sort of conversation, and now you're just asking me as a fellow citizen what my opinion would be, and as a fellow citizen who does know a little bit about the process, and one who, I just don't think we have enough history with respect to impeachments to say we know based on one impeachment what would happen in another one. So I guess the lawyer in me would say if you've got a lot of evidence and a lot of smoking guns, I don't think you hold back on that evidence, but I also, just like probably everyone who's been following it, I do understand that there's a reason to keep things simple, because you do have to have public buy-in. So, so I guess I would agree if the heart of the matter is let's don't make this too complicated that the average American gets confused by it. But at the same time, I think a thorough investigation is what we're all owed. We're probably owed a thorough investigation of 6,000 more things. I mean, I think we're probably already at a point where only a small number of the things that could potentially be investigated. And I think they've already narrowed the House of Representatives, because there have been many members of the House of Representatives that have called for impeachment over a myriad and numerous other actions of the president, and they haven't acted on them. So I guess I feel like big picture, maybe they're doing fine. And I think the bigger question is whether people are going to abide by the law and the Constitution again in how they proceed. And the other, not a constitutional law opinion, but just my personal opinion, because it kind of runs hand in hand. Students ask me this, how do you feel if President Trump is impeached yet not removed? And that's already a question that I've answered. That's plausible, but and you've probably heard a lot of commentators who are geeked out on the Constitution, and not geeked out just generally. I'm like, again, it's our freedom, right? It's what keeps us living in a free country, right? People say that, and we do red, white, and blue, and we have our barbecue, but I don't have any sense of what it's like to not live in a free country. But I think about it enough that I am horrified at the prospect of not. And so even just impeaching is a line. It's drawing a line and saying the Constitution matters. And so personally, I think that's important. And then again, we'll have to do it after this is all over. Next question is, but what if that contributes to another term of someone who has violated the Constitution? And I think we're totally out of my zone of expertise at that point. But again, I'm just sticking with, if you violated the Constitution and you took an oath to uphold it, and it's your job to impeach someone who didn't, then that's a pretty clear answer to me. And then maybe the rest of us have to convince our fellow Americans that that's important, right? I think the other piece of this, and why tonight is so important in doing things like this, is if we don't have an electorate that's vested in the Constitution, you can't expect Congress to do much, because they represent us.
So, hi.
Okay, last one, right?
I hope so.
You're a lot of pressure on you. Okay, no, not at all.
So you mentioned that one of the thing that keeps you up at night is tyranny. How would you, given
Good takeaway. You got it. You get an A. Okay,
if I
go
took
ahead.
nothing else, it's that. But given the amount of gridlock that presidents face, the amount of executive orders that are issued keeps increasing. Do you think any of that is going to lead us to tyranny, given the amount that it's becoming more and more prevalent for presidents historically to issue executive orders? Do you think that will eventually lead us to tyranny, or what is the solution?
Well, maybe that's a slow road to a subtle kind of tyranny, but it could, right? I would say that, again, you've been a very good student of the evening, because I skipped. There's also a part of this, covering this part of constitutional law, where you cover treaties versus executive agreements. And it's a similar sort of thing that while Congress, where the Constitution says the president can't enter into a treaty without Senate approval, the president has just started entering into executive agreements. And as you've pointed out, it's kind of hard to be a check on that sort of thing. So again, this executive power creep has been creeping over time. And so it's very astute. It's very much understanding the lesson and the takeaway that the tyrannical creep can come from any direction. It can come from a president of any party. It can come from the judiciary. It can come from the legislature. And definitely executive orders are a version of that, because it's not being checked. It's only one branch of the government acting. So even as you have Democratic nominees for president saying, I'm going to do X, Y, and Z on the first day via executive order, the con law geek in me is kind of like, oh no, maybe I'll like what you do, but as far as a principle, it is a problem. But you're right also that it's gridlock, right? That it's I can't promise to do much. And the reality is, historically, the president is not supposed to be a powerful position as a matter of law. It's not supposed to create law. And so that's why presidents want more power, because it's kind of a bully pulpit, we'll follow you along based on you being persuasive sort of job. And we got to convince Congress to pass the law, or I have to before I can actually sign it. Nobody, once they get in there, they want that job to be more powerful. There are people calling on them to do important things. So I get the challenge. And like many things in constitutional law, there is no one right answer. But I think, again, and I keep coming back to it, I think the answer is being an educated electorate, being civically literate, and us being engaged so that we, again, we're the check on that tyranny, right? So if you start to do it too much, or maybe we don't vote for you if you promise to do it, right? Like even if we kind of like what you're saying you're going to accomplish, we don't want the candidate who's not saying they're going to do it in concert with the legislature. Maybe they all should be talking more about how they get senators and members of Congress that will help them get there. So excellent question, and you definitely got the takeaway. And you've been a great crowd on the Friday night, so thanks for having me.